This is Bart Peterson, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Greg Gilchrist, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Dan DeMarco, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
Hello, everyone. This is Tom Fox. I'd like to welcome you to the FCPA Compliance Report on the Compliance Podcast Network. In today's episode, I visit with Jesse Caplan. Jesse is a managing director at Affiliated Monitors, and we take up the U.S. Department of Justice's Antitrust Division's recently released evaluation of corporate compliance programs in criminal antitrust investigations. Caplan explains how this supplements the prior leniency program, and most importantly, what does it mean for the compliance practitioner, particularly the anti-bribery, anti-corruption compliance practitioner. It's a fascinating exploration of a current event that is seemingly going to change the face of antitrust investigations and, most importantly, corporate antitrust compliance programs. I know you will enjoy it, and more importantly, I know you will find it useful. The FCPA Compliance Report is a production of the Compliance Podcast Network and a proud member of C-Suite Radio. Hello, everyone. This is Tom Fox, back for another episode, and today I'm joined by Jesse Caplan, the Managing Director for Corporate Oversight at Affiliated Monitors. We are here today to visit about what I think is certainly one of the most significant changes the Department of Justice has put out, specifically in the area of antitrust enforcement, but it may have broader implications for the compliance practitioner going forward. So, Jesse, with that, first of all, welcome and thank you for taking the time to visit with me.
My pleasure, Tom.
Jesse, last week we had the release of a document entitled The Evaluation of Corporate Compliance Programs in Criminal Antitrust Investigations. You are a former DOJer, specifically in the Antitrust Division, and I also took that role on in the state of Massachusetts Attorney General's office for a time. So I was wondering if you might be able to start with giving us a bit of a review, as many of my listeners are going to be anti-bribery compliance practitioners. What's the U.S. antitrust law? How did compliance programs relate to it? And then maybe what changed?
So first of all, as you mentioned, last week the DOJ Antitrust Division came out with this, basically a new policy and guidance. And in the rollout of the new policy, the Assistant Attorney General in charge of the Antitrust Division for the Department of Justice, Macon Delrahim, called it a new model for incentivizing antitrust compliance programs. So it certainly is relevant to all compliance professionals. And just at a very high level, this new model that's been rolled out by the Department of Justice revises and to some extent liberalizes the circumstances under which the Department of Justice will give credit to antitrust violators in criminal cases when they can show that they had an effective antitrust compliance program. A little bit of background on the antitrust laws. The federal antitrust laws that most people have heard of or are familiar with are Sections 1 and Section 2 of the Sherman Act. And Section 1 in particular prohibits unreasonable restraints on trade. And in all cases, in order to be a violation, a criminal violation, there has to be some kind of concerted action between typically competitors. So, again, the antitrust law, Section 1, prohibits really a concerted action, whether it's an agreement or a conspiracy, that would unreasonably restrain trade in commerce. So what constitutes a criminal antitrust violation? Because the Department of Justice can investigate antitrust violations either civilly or criminally. And in this case, it's important to know what's a criminal violation because the new policy only applies to investigations and prosecutions of criminal antitrust cases. So a criminal antitrust violation is one that is typically called a per se violation of the antitrust laws. And what a per se violation is one where the courts have determined that that type of conduct always or almost always, is harmful to consumers, is harmful to the free market system, and is therefore always considered an unreasonable restraint on trade. And there are several per se violations of the antitrust laws that most people are familiar with. So, for instance, price fixing is a per se violation of the antitrust laws. Bid rigging and allocating or dividing markets are all per se violations of the antitrust laws. And they all involved concerted activity between competitors. So in almost every criminal antitrust case, you're going to have a situation where you're going to have multiple actors. They're typically going to be competitors, and there's going to be some kind of conspiracy between them. This new policy and how it's different and significant from the situation before July 11th and DOJ policy before July 11th. Before July 11th, the Department of Justice had really just what they called an antitrust leniency program. And what that leniency program was really pretty straightforward. And what it provided was that if a co-conspirator in a per se criminal antitrust matter was the first one to come and self-report to the Department of Justice and to cooperate meaningfully with the Department of Justice, that co-conspirator could avoid criminal prosecution under the antitrust laws, and typically would avoid criminal prosecution under the antitrust laws. However, if you weren't the first one in, you could not avoid criminal prosecution under the antitrust laws. You did not get any credit under the leniency program. So what it really constituted was a race, and the DOJ called it that. It was a race to see who would be the first ones to go and self-report to the Department of Justice and to cooperate with the Department of Justice. And even if you were arguably a good corporate citizen and found out about the violation, but you were not the first one in, let's say you went to the Department of Justice, but one of your co-conspirators got there the day before you, if you missed it by that day, you were not going to get credit under the DOJ leniency program. And what this new policy does, it doesn't get rid of the leniency program, but it gives companies that are good corporate citizens who can show that they have an effective compliance program the ability to get credit for that compliance program at the charging phase of an antitrust case, even if they were not the first one in.
So, Jesse, that is a major change, obviously. Is it something that you have anticipated or you would have expected, or is this really something out of left field?
You know, I don't really think it's something out of left field, and I think it's consistent with where the Department of Justice is going, and arguably it is the next step after the leniency program has been in place for quite a number of years. The Assistant Attorney General in charge of the Department of Justice talks about that the leniency program, where there's really only one winner, it was a winner-take-all, has and had its positive impact for law enforcement because it's providing great incentives to be the first one to come and cooperate with the Department of Justice. It didn't necessarily provide incentives to any other companies for truly making sure that they had a very effective antitrust compliance program. And what this does now, it provides incentives to all companies who may find themselves being investigated criminally for an antitrust violation. It provides incentives for all those companies to ensure that they're good corporate citizens, that they have effective compliance programs, because now, if that's the case and they can demonstrate that to the Department of Justice, they can then potentially get credit for that at the at the charging phase of a antitrust criminal investigation and prosecution. And the way that they will get credit is that they can be eligible for a deferred prosecution agreement. As we know, if you have a deferred prosecution agreement and you fulfill all those terms, you can then avoid prosecution.
Jesse, one of the things that has struck me, certainly in the anti-bribery, anti-corruption compliance world, is that the Department of Justice has evolved in its thinking and evolved in the incentives it has given to corporations to cooperate. So now we have a corporate enforcement policy that has a presumption of a declination if certain factors are met. But it seems to me the DOJ has been moving towards trying to get greater cooperation with corporations, giving them real incentives to not only self-report, but to cooperate. Do you see this initiative by the Antitrust Division as consistent with that DOJ evolution?
Explicit, if not implicit, and implicit in this new policy change is that they do expect that good corporate citizens will not only have a strong compliance program, but that compliance program would have as an element that when a violation is identified by the company, that they will, number one, self-report, but that they will also then meaningfully cooperate with the Department of Justice, and that they will then remediate the problem as well. So, yes, so this is more towards that trend of providing incentives to not only self-report, but also to provide meaningful cooperation.
Jesse, the evaluation, or excuse me, the document itself starts out with three questions, which are entitled three questions a prosecutor is to ask, and it labels them fundamental questions. Is the corporation's compliance program well designed? Is it applied earnestly and in good faith? Does the corporation's compliance program work? Those three questions are also a part of the Anti-Corruption Compliance Program 2019 guidance. So there is some overlap, but I found a fair number of differences. And so I was wondering if you might be able to just kind of go through the substance of what the DOJ is mandating around antitrust compliance programs and give us some of your highlights.
One thing I want to mention, and this might seem obvious to some people, but frankly is not all that intuitive or obvious to most people. And that is, when you talk about anti-bribery, anti-corruption, a violation of the antitrust laws, of a per se violation, which is a criminal violation, is really a fraud. It is corruption. When you are entering a conspiracy with other competitors in your market to either fix prices or to rig a bid or to divide up your customers, you are committing a criminal fraud. And it's a criminal fraud on the consumers or the customers. In many cases, the customer is the government. And it's also a fraud on the free market system. And it's an impediment to a free market system that we all rely on. So while to some people they hear the word antitrust and they think that this is really very complicated and not intuitive, at the end of the day, an antitrust violation is a fraud. Just like bribery can be a fraud or other type of anti-corruption or corruption law violations. So in terms of those three questions, so the first one, is the compliance program well designed? The key thing for this new antitrust policy is that it be a well-designed antitrust compliance program. And I think this is where, for some companies, if not many companies, this is going to be an area where they really need some improvement. And that is because I think many, many companies have compliance programs, corporate compliance programs, and they could be pretty well designed. But when it comes to the antitrust aspect of compliance, they are superficial or non-existent at all. And in order to get credit under this program, you have to have a well-designed antitrust compliance program. And according to the guidance, what that means is that it has to be a compliance program that is designed to prevent antitrust violations. And where an antitrust violation may occur involving your company, it's supposed to be effective in identifying that violation and then have mechanisms for making sure that the company self-reports that violation to the government, is prepared to cooperate with the government, and is also prepared to remediate the problems that led to that violation. So that gets to the first question. The second question was, is it implemented in earnestly and in good faith? I think, that's similar to any other compliance program. But I think a key aspect here is a company needs to know who are the individuals within the company that are most likely to be in situations where they can engage in antitrust violations. Those people may not really be all that aware or knowledgeable about the do's and don'ts of what they can do in a particular situation. I'll just give you an example. Think of a conspiracy to fix prices. Where that's going to occur often is with the sales team. Representatives for competing companies do get together from time to time. They may go to a professional association. They may see each other as they make a pitch to a customer. And they have to be trained and educated and, frankly, audited that they are not entering and engaging in the types of conversations and the types of exchanging of information with their competitors, even at something like a trade organization, that could lead to an antitrust violation and certainly an investigation and potentially a prosecution.
Well, Jesse, unfortunately, we are near the end of our time today, or actually we're at the end of our time, but I've been visiting with Jesse Caplan, the Managing Director of Corporate Oversight at Affiliated Monitors. We've been discussing the Antitrust Division's evaluation of corporate compliance programs and criminal antitrust investigations. Jesse, I'm sure we will be continuing this conversation.
Thanks, Tom.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report. If you want more information from me, you can email me at tfox@tfoxlaw.com. You can email Jesse at jkaplan@affiliatedmonitors.com. I hope you'll join me again next week where we take up another topic related to FCPA compliance and ethics. FCPA Compliance Report is a production of the Compliance Podcast Network and a proud member of C-Suite Radio. Thanks so much for listening, and I look forward to visiting with you again.